I have certainly certain differences of opinion. I think in forums of this nature, I do not think we need to discuss about a minority judgment. I will only read. I do not want to say anything except what the Supreme Court judgment has said. I will read out the Supreme Court judgment. I certainly have problems when he's talking about a minority judgment, because Justice Gawai gave a minority judgment, and then Bella Trivedi also had certain difference of opinion. I have those difference of opinion. I have read comprehensively the Supreme Court judgment in the last 3-4 months. I have a copy of it. Let me read out the operative portion. I think as you have initially made your remarks, Mr. Sridhar, we will only go by what the Supreme Court says. Number one, on August 1st, 2024, the 7-judge constitutional bench of the Supreme Court, if you have any difference of opinion, you have every right to intervene, sir. On August 1, 2024, a 7-judge constitutional bench of the Supreme Court upheld the validity of subclassification. I request all of you not to use the word categorization. The Supreme Court nowhere used the word categorization. They talked only about subclassification. I also would like to tell all our friends here, Supreme Court nowhere talked about mala madhya. We should not use that expression at all in the 550-page judgment. So what did the Supreme Court said? On August 1, 2020, 7-judge constitutional bench of the Supreme Court upheld the validity of subclassification within the scheduled caste and scheduled tribe categories. Am I right? That is the essence of the Supreme Court judgment. However, I think that is very, very important. The 6-1 majority also noted that scheduled caste notified under the presidential list of 1950 under Article 341 were not a homogeneous group. Very, very categorically they have said that. That is what is important for our discussion. We have to go by a majority judgment. Supreme Court is Supreme Court. And then homogeneous group. They faced varying degrees of discrimination. Supreme Court has recognized that. There are varied degrees of discrimination. I'm quoting the Supreme Court. No interpretation. I teach journalism. I don't want to interpret. Facts are facts. Facts are sacred. Supreme Court is sacred for me. The decision overrules the 5-judge bench decision of the court of E.V. Chennaya versus State of Andhra Pradesh, which gave the judgment, as you have said, in 2004. Let me further say, it's very, very important for all of us to understand in perspective. Does Article 14 permit subclassification? The Supreme Court, in the majority opinion, said yes. Under Article 14 endorses, I'm quoting the Supreme Court, parity of treatment under the parity of conditions, not sameness. Subclassification is a facet of equality and it is permissible. In the majority judgment. Majority judgment. And then, second, this is important for our discussion. Only 7 points I want to make. Number 2, are scheduled caste a homogeneous group? Supreme Court categorically in the 6-bench judgment said, no. Inclusion in the presidential list is not an indication of homogeneity. There is a historical evidence to suggest there are varying degrees of backwardness within the scheduled caste group. And Supreme Court has quoted 27 judgments on this issue, and perhaps even little more. Then another important discussion which is required for us. Does subclassification amount to tinkering with presidential list? Very, very important for our discussion. Are we tinkering? As we very rightly pointed out, 341, we cannot exclude or include. Supreme Court in about 20 pages have very clearly said, no, it is not tinkering with 341. What did the Supreme Court said? The count of E.V. Chennaya versus State of Andhra Pradesh incorrectly held that subclassification amounts to, I'm quoting the Supreme Court, amounts to tinkering with the presidential list. Subclassification now, the Supreme Court says, does not, let me I have a problem with my site. Subclassification does not entail inclusion or exclusion of caste from the presidential list, and therefore it is not tinkering. We are not changing. 341. One more point. Does Indians have any restrict subclassification? I think for our discussion, OBCs are not required because Indira Savani case only deals with OBCs. We're only talking about scheduled castes and scheduled tribes. Though my friend quoted extensively, that is only relating to OBCs. They did not look at SCs and STs. Now, one more important point. Do states have the power to create subclassification? Supreme Court examined this very, very comprehensively. Supreme Court said, yes, the states have the power to create subclassification within the SC/ST under Article 14, 15, and 16, which I have quoted quite extensively. Then comes last point. What are the limits for subclassification? I'm quoting again the Supreme Court. Classification in which certain castes within the presidential list are excluded completely from the benefit of reservation. Are subclassification subject to judicial review? I think he has made it very clear. Yes, Supreme Court says. States cannot act according to their whims and political interests, which he did not mention, but that is my worry. State cannot, whims and fancies and political interests, they cannot have it because recently we carried out a survey in Telangana. Earlier government also carried out another survey. There are some whims and fancies and political interests there. Let me read out the Supreme Court. Yes, states cannot act according to their whims and political interests. Any state legislation creating subclassification must be based on data and subject to judicial review. But what is important, I'll just take one point. The judgment talks about, this is slightly my interpretation, deepening of social justice. It talks about ensuring equality. It talks about ensuring diversity. Supreme Court also talks about suffering from historical and social disabilities and social discrimination. And Supreme Court also, as I have said, it is not a homogeneous group. Lastly, I will exactly quote what the Supreme Court said and then wind up. 6 of the 7 judges have now ruled that 2004 judgment was wrong. In his judgment on behalf of Justice Manoj Mishra, Chief Justice Chandrachud held that SC communities are not a homogeneous class as ruled by earlier judgment. He disagreed with the view that both of them have disagreed. 4 of them have agreed with them. That's the 6th judgment. He agreed with the view that the act notifying the list of SCs create a deemed fiction. They have used the word deemed fiction, that all of them have a similar status. In other words, it's fictional to think, it's fictitious, unrealistic to think that not all of them belong to the same group. He disagreed with the view that the act notifying the SCs created deemed fiction and all of them have a similar status. Lastly, it is true that they have a common constitutional identity as scheduled caste based on their experience of untouchability. And the Supreme Court talked about both of them, all this caste based untouchability and discrimination, but that does not mean there is no heterogeneity. There is heterogeneity. That does not mean there is heterogeneity among them. He cited historical, empirical evidence, etc., then went about doing it. Lastly, the court permitted subclassification of scheduled castes, but the state should have rational basis for doing it. Empirical, scientific, evidence-based. I do not want to quote several other judgments because he is already quoted. If you have any kind of a difference of opinion with me, I very fairly, objectively quoted what the Supreme Court said without any interpretation. So my appeal is, let us not discuss the minority judgment. Minority is a minority judgment. It's a 6:1 judgment. Let us not discuss creamy layer, because in the Supreme Court they did not agree on a creamy layer. They only incidentally mentioned, if I may use that word, creamy layer is not of concern for us here. Then, of course, in the backward classes, there is a creamy layer. All of us are fighting that case. Myself, there is an appeal in the Supreme Court on the creamy layer issue. So, this is what I want to say. Number one, we will confine our discussion to 6-bench judgment, majority judgment, and what they have said, where they have discussed, or they have identified 6 issues which are important, crucial for a discussion. I will appreciate if discussion is confined to that. Then it becomes easy for us to move forward. When I get an opportunity, I will, because I've been interacting with these groups for the last 3-4 months, informally, formally, with the student, with the various groups. Then way forward comes, is there a solution? 100% there is a solution, provided we have commonality on these issues. Commonality on this issue. Lastly, I hope this discussion is going to be very, very harmonious, very, very academic. It is not acrimonious, because 10 discussions I have attended all over. I spoke 3 days ago in Lucknow, where majority of them did not agree with me. I don't want this discussion to have that kind of a nature. They are very, very distinguished advocates and distinguished professors, and we must find a solution. We can only find a solution provided we agree on the majority judgment. Let's not get extraneous issues like creamy layer, minority judgment, etc., etc. Then we will be in a position to find a solution. I thank all of you for giving me this opportunity. I did not want to intervene. I only came to hear. I thought I will learn. But then when there's some kind of a direction, a discussion take place, I thought I should try to intervene and make my point. Thank you very much.